All
So
right,
who's talking?
let's get underway.
Okay, so
We
I don't
are
know what,
broadcasting,
no clue
so
what went wrong, but can people hear, can you all hear me?
it's okay. We can definitely hear you, Mark. Thank you.
All right, very good.
The delay, everyone. A little technical difficulty, but we worked it out and we're ready to get rolling. For those of you that don't know me, my name is Martin Daly. I'm the Director of Water Quality Programs for CDRPC's Local Government Workshop webinar series. Today's webinar is Ethical Considerations in Planning and Zoning Decision Making. We have an hour-and-a-half presentation prepared for us from Mark Schachter, which is going to be very engaging. I'm looking forward to it. For those of you that do not know us, CDRPC is a regional planning and resource center that serves Albany, Rensselaer, Saratoga, and Schenectady counties. We foster intergovernmental cooperation, communicating, collaborating, and facilitating regional initiatives. We work with partners to help them address regional issues. We established this webinar series to help planners sharpen their skills and as a vehicle for Planning and Zoning Board of Appeals members to obtain their credit hours. As a reminder, Planning and Board and Zoning Board members are required by state statute to obtain 4 hours of training per year. And town, village, and city zoning board of appeals and planning board members, as well as county planning board members, must receive training. Municipalities have a wide latitude in defining what training is acceptable for credit. So after each webinar in our series, each attendee that registered with an email address will receive an email confirming their attendance in lieu of a certificate. This email may be submitted to your municipality for consideration of credit. For those of you that are practicing AICP planners, we have submitted this session for 1.5 hours of CM credits. We are not able to certify this for ethics, but we were able to get 1.5 hours of CM available for this session. Our attendees do join with video and audio off for security purposes, but since we have a large audience and we hope to really engage in a spirited dialogue, we'll unmute attendees to allow them to ask questions directly. All you need to do is type a note into the chat box down below. I see somebody's already used it, and we will unmute them to be able to present them with the opportunity to ask Mark a question. Hopefully that'll encourage us to get into some dialogue about some questions folks have or some issues people may have concerns about or want to bring up on this program. If you simply type a note in the chat box or the question function, I will be able to unmute you to engage in that. Our presentation material will be archived as a video. Mark is just going to be talking to us, so there's not going to be a presentation associated with it, but we do record these. We will post them on YouTube, and that link will be available from the Eventbrite page, the same page you used to sign up for your webinar. Again, today's webinar is Ethical Considerations in Planning and Zoning Decision Making. Ethical issues arise more frequently in planning and zoning decision making than many people realize. Our presentation today will include a discussion of ethical legal requirements, conflicts of interest, recusal, site inspections, and other related issues. A whole bunch of things I'm sure many of you are chomping at the bit to get questions answered from Mark. For that, I'm going to turn it over to Mark to share with us his perspectives on ethical considerations in planning and zoning decision making. So Mark, thank you for joining us today on a snowy Wednesday morning. I really appreciate your time.
It's my pleasure. Good morning, Martin. Thank you very much. And I'm assuming
Yes.
people can, I'm saying people can hear me. Is that a true statement?
That is a true statement, yes.
Very good. So do we have any sense of how many people we have listening on?
We have about 50 people.
Excellent. Okay, so for everyone's benefit, I haven't the faintest idea. It's a little out of the box doing these things virtually because for starters, I haven't the faintest idea if any of you know me or if none of you know me or if many of you know me. Looking at the municipalities in which you work, it's my sense that probably some of you know me, but most do not. My name is Mark Schachter. I'm an attorney in private practice. I say I'm an attorney in private practice because it's true, and I like to say things that are true, but I feel like I'm sort of a local government employee because the vast majority of my private practice is devoted to working for local governments, and the vast majority of that is working for local governments and planning and zoning. So what do I mean by that? What I mean by that is that most of my professional time is spent working for and attending meetings of planning boards and zoning boards of appeals. That means that I do a lot of what I'm assuming many of you all do, although again, unlike most conferences that I do presentations at, I don't have a way to know for sure. I've been doing what I do for going on, or maybe a little more than 37 years. I'm not a young person. The next thing I'm going to say is something I'm fiercely proud of and also hugely embarrassed by. And that is that I used to keep track of how many planning board, zoning board of appeals, and that type of meetings I had been to. And I thought this is both a healthy and a remarkably unhealthy thing to keep track of, as that number crossed 2,500. I'm not making that up. It's not as impressive as it might sound or might not sound. If you go to 100 nighttime meetings per year, which is about what I do, and you do what I do for 30 years, there's 3,000 right there. It's not 3,000, but it's a big, big, big number. I'm closing in on 200 training sessions and presentations and the like. So I do this a lot. This is about the speed at which I speak, but if people think I'm going way too fast or way too slow, please interrupt and say so. I can do what I do at 33 1/3 RPM, or more likely 78 RPM, or numbers in between. This is about the volume. I hope I'm not yelling at you all. If I am, please tell me that. If you can't hear me, please tell me that.
We can definitely hear you.
Good. Following Martin's lead, and different than most conference presentations, I'm not going to spend much time telling people where the emergency exits are. I'm not going to spend much time talking about keeping your cell phones turned off, not smoking cigarettes, and the like. I don't think those things are particularly relevant in these days of COVID. What I will do, and Martin said this as well, I'm just going to emphasize, is I can drone on about ethical issues in planning and zoning decision-making far, far, far longer than the hour and a half we've allotted, far, far longer than the rest of Wednesday. That's not our goal. My goal is to raise some issues about ethical considerations for you to think about, hopefully some take-home stuff, but also if you have a question or comment along the way, obviously a question or comment directly on point to what we're talking about, at least at the get-go, I'm going to encourage you to jump right in, because in my experience, I like to think I do a decent job in presentations, but me droning on for 90 minutes versus some engaging dialogue with those of you who are attending, you're going to pick choice 2 every time you have that option. So I am going to encourage questions and comments along the way. Again, if we get too bogged down, maybe we'll change our mind about that. So before I get further into, or before I start getting into the substantive issues, I want to bring the crowd down a little bit in terms of what your expectations might be. I do lots and lots of presentations about lots and lots of different topics. Many of them lend themselves to making at least a decent number of hard and fast, black and white, rule or law-based comments. So I can say the law requires A, B, C. I can say there's a regulation that requires, what am I up to, C, D, E, F. Ethical considerations and ethical issues in planning and zoning decision-making, in my humble opinion, don't lend themselves really super well to hard and fast, black, white, bright lines. We're going to talk about a few black, white, hard, fast, bright line issues, but most of what we discuss is not going to be hard, fast, black, white, bright line issues. And the way I'm going to maybe bring you down is if you're expecting remarkable insight with take homes of, okay, here's what the law says, here's what the regulation says, here's how I have to behave, you're going to be woefully disappointed. In my humble opinion, a lot of the most important and most valid answers to ethical dilemmas in planning and zoning decision-making are really what's the most commonsensical, and what people who, my colleagues and I, those of you who know me, my colleagues and I are fiercely resistant to the notion of legalese dominating the world, the notion that lawyers should only speak in language that others who attended law school can understand. We're fiercely resistant to that, and there's not going to be much legalese in this morning's discussion. There's not going to be no legalese, but there's going to be not much because I don't like it. I'm only going to use it when I feel compelled, but the vast majority of what we talk about this morning, in my humble opinion, and again, if this is disappointing, I'm sorry, but the vast majority of what we're going to talk about is really commonsensical and involving taking the highest road reasonably possible. I'm choosing those words very carefully. The highest road reasonably possible under whatever ethical dilemma situation is being presented. So I think the name of this is Ethical Considerations in Planning and Zoning Decision Making. There's a lot of issues that could fall under that umbrella. The title is purposely broad so that I can fit a lot of issues under that umbrella. One of the things I'm going to do is I'm going to talk about what I call the minimum standards versus the higher standards or goals. In many instances, the higher standards or goals won't be standards at all. They will be just goals. They will be aspirational. They will be above and beyond the minimum standards. And you're going to hear me talk, I think, about striving high. And what I mean by striving high is seeking more than just the minimal compliance with whatever the standards are. And you're going to hear me use the word must sometimes, and you're going to hear me use the word should sometimes. And it's very, very important that I point out that I'm choosing those words carefully because there's an important distinction. Because I'm an attorney and because my job is to guide people through the planning and zoning process in ways that are lawful and not susceptible to successful legal challenge, if I say, I'm going to tell you things that are rules, things that you must do. When I use the word must, I mean must. But I'm going to spend more time than telling you the must rules, telling you things using the word should. And when I use the word should, I'm talking about aspirational goals that I am suggesting you aspire to try to strive high and to seek more than minimal compliance. It's extremely, extremely important that I make clear that distinction to avoid any misunderstanding. So it's very important that you don't leave this morning's discussion saying, well, Mark Schachter said that I must do blah, blah, blah. If what I really said is you should aspire to do blah, 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 because there's a very important distinction. You can get in a lot of trouble, and we'll talk about the trouble later. You can get in trouble for not doing something I say is required by law. You may or may not be able to get in trouble, or you may or may not get in trouble for failing to do something that I say would be a good thing to aspire to. So, and I don't know, looking sort of, Martin gave me a sneak preview just of where you all are from. It looks like a bunch, not surprisingly, from the Capital District, some Saratoga County. I didn't see a lot of from the further north. My practice varies from very, not so much urban, but suburban-based municipalities to extremely rural-based municipalities. And there's a lot of difference in how certain ethical issues have to be approached. When, I don't want to call them my competitors, but when colleagues of mine that are Albany-based and Department of State-based and governmentally based and the like talk about ethical issues, I will sometimes hear them say things like, if you're a member of a planning board or zoning board of appeals and you're acquainted with the applicant, you are not allowed to participate in review of the applicant's application. The smallest town, not geographically, not by acreage, but by population that I worked for had, at least at one of the recent counts, 428 full-time year-round residents, 428. What would be the result of rigid application of the quote-unquote rule that I just mentioned, which is not a rule at all, if we were to say in that particular municipality, if you have ever met or are acquainted with the applicant, or perhaps on the other side of the coin, somebody who's vehemently opposed to the application, you are not allowed to participate as a planning board or ZBA member in review of that application. The practical result of that would be shutting down our planning board and our zoning board of appeals, because in such a small rural community, everybody knows everybody. And it's not just a saying, it's the truth. So you have to take things with a rule of reasonableness. And that's why I said that you're going to strive, or hopefully going to strive as high as possible, as reasonably possible. And I think I used that word, and I used it on purpose. So I'm going to open with some of the general principles that are involved in ethical considerations in planning and zoning decision-making. And in my experience, which I've just confessed to you is having gone around the block a whole bunch of times, in my experience, very, very few people disagree with the fundamental general principles. Very few, essentially nobody disagrees with these general principles. I'm going to recite them, and then we're not going to spend any time on them. The general principles that I suggest, these are not precisely written in law, but the general principles that I suggest govern ethical issues in planning and zoning decision-making include these things. Officials, planning and zoning officials, should be objective and unbiased. Planning and zoning decisions should be made on the merits of the application, regardless of who is the applicant or who are the proponents of the application, and regardless of who are opponents or opposed to the application. Decisions should be made only on the basis of information presented and reviewed at open public meetings. We can stop right now, we can all go home, and we can all agree that those are the basic, fundamental, general overriding premises, and that we're all going to live up to those 100% of the time. They're never going to be complicated. They're never going to be hard to live up to. End of story. That's not how real life works. But to reiterate sort of in more plain and simple terms, when we talk about things like decisions made on the merits of application, regardless of who the applicants or opponents are, that means that if an application is submitted by Mother Teresa, it's reviewed generically, independently, not with regard to the fact that it's Mother Teresa who submitted the application. The same or substantially similar application is submitted by Jack the Ripper. It gets the same review from a planning board or zoning board of appeals, notwithstanding the fact that the applicant is Jack the Ripper. Continuing on the generally accepted principles, we're going to maintain integrity, we're going to avoid conflicts of interest, and we're going to avoid appearances of impropriety. We're going to talk about those things, those principles, a bunch a little bit later. When you ask me, what are the best standards to apply to ethical behavior? I have what some criticize as a very uncreative answer. And my answer is the best standards to think about in your mind when you're considering ethical issues are the duck test. If it quacks, swims, and has webbed feet and a bill, then it's probably a duck. The smell test. If it's rancid or foul or malodorous, then it's probably not right. And in my experience, especially the gut or sleep test. What do I mean by that? If it feels uncomfortable and you're losing sleep, or you feel yourself feeling anxiety over a particular ethical issue, then something's probably not right. Aren't those magical, intensely legalistic guidelines? No, of course not. One frustrating thing to me and my colleagues, really super frustrating, is that we would like to be able to say to you, here is what the courts of the state of New York have said. This does constitute ethical behavior. This does not constitute ethical behavior. It's crystal clear. Not only have the courts of New York State not given us that type of guidance, but there's sort of an annoying trend. And I have no idea if there are any other attorneys on. Usually there aren't, and that's fine. Sometimes I have some really, really poor lawyer jokes. We're not going to do those. But lawyers like me are very frustrated by what I'm about to say, which is this. There's something of a trend in New York courts when dealing with ethical issues in particular to say something like in a court decision, we have reviewed the set of facts where planning board member Jones did the following. We believe that Ms. Jones is guilty of an ethical violation because she participated in planning board review of something she should not have participated in. Or the flip side, our court finds that Ms. Jones is not guilty of any ethical violation because it was perfectly appropriate for her to participate in this planning board decision. But either way, there's a trend for the court to then add words like this in its decision. Words like this. We note in this that this decision is limited to the specific facts and circumstances of this application and should not be relied upon in providing guidance and judgment about further behavior of planning board and zoning board of appeals members. I hate that language in a court decision. I hate it because I think it's wimpy. I hate it because I think if you're wearing the black robes and being judges, you should give us more clear guidance. And my job is about giving you guidance with predictability. And that language in a court decision does the exact opposite. It tells me that I can't give you guidance with predictability. So that's enormously frustrating. Our view, my colleagues and I, our view is if you're in an ethical situation and if you're in doubt about whether to, for example, disclose something or a potential connection or recuse yourself from consideration of a particular application, with one caveat, maybe two, but we say if you're in doubt, err toward the side of disclosure and recusal. We say err toward the side of disclosure and recusal. It's a graphic example of the shooting high, the shooting for the highest standard possible, even if it's above and beyond what might be required. Why do we say that? Not just because we're saying shoot high, but for one very important legal reason. There's a substantial risk for failing to recuse yourself from consideration of an application if it turns out you should have done so. There's much less risk, especially if your board has alternate members, there's much less risk for recusing yourself from an application that really you didn't have to recuse yourself from. What are the risks I'm talking about? It's really only one risk, but I labeled it, I think, fairly as a substantial risk. If I am a planning board member and my board is reviewing a controversial, complex application for pick whatever you want to pick, and it's going to be months of public hearings and lots of anxiety from both sides, or however many sides there are of the issues, somewhere along the line or early on, presumably somebody says, I should not be participating because of some nexus between me and the applicant. It doesn't matter for the moment what it is. And let's assume that if push came to shove, it was a valid nexus, meaning, or a valid objection, meaning I really shouldn't participate. But I'm stubborn, I'm bullheaded. Those things are true. I am stubborn, I am bullheaded, and I decide to participate anyway. And I vote, and I have a meaningful role in the participation. It's a close, let's say it's a 4-3 vote, and I voted in favor of the application. And let's say, and I've, vocally participated throughout the review. And somebody challenges the approval. It's an approval. Somebody challenges the approval, and the court decides that I should not have participated. Here's what happens in that scenario, and this is in real life what happens. The court does not say, well, Mr. Schachter participated in the scenario, and there was a 4-3 vote to approve. Since he should not have participated, his vote is stricken from the books. It's no longer a 4-3 vote to approve. It's now a 3-3 vote. It's deemed a denial because it didn't get approved. That's not what happens. What happens is, I usually ask for a show of hand and somebody to tell me what they think happens. That's not so easy here. I'll just continue. What happens is the court invalidates the decision due to my participation and does what? It does not say, or it rarely says, let's just go back to the night of the vote and let's have the vote taken again without Mr. Schachter participating. That's not what happens. What does happen, I know that some of you know, but I'm surmising that not necessarily all of you know. The court says this matter must be reconsidered and reheard by the planning board. And what does the court mean when it says this matter must be reconsidered and reheard by the planning board? What the court means is reconsidered and reheard from scratch, from day one. We just had 10 months of meetings till 10, 10:30, 11 o'clock at night, considering this application. We've got to do it all over again. Trust me, because I've been through this, although I've obviously never been the board member in question, but trust me, I've been through this. If that scenario plays out the way I just described, you, the member who should not have participated, excuse me, the member who should not have participated has become extraordinarily unpopular with a large group of people. Of course, extraordinarily unpopular with the applicant. Of course, extraordinarily unpopular with the public, presumably, because nobody wants to go through it all again, I wouldn't think. But who have you become most unpopular with? Your fellow board members. That's who you've become most unpopular with. So, if in doubt, and there's a reasonable either concern or objection, whether it's raised by somebody else or you have it yourself, if in doubt, err toward recusal. If you recuse and it really wasn't necessary, again, especially if you have alternate board members, avail yourselves of your alternate board members. Let them serve on this complex, controversial matter. Even if you don't have alternate board members, hopefully the other board members are numerous enough and attending enough and vote in a way that creates a decision that can be carried forward without your participation. But that's the reason why we suggest what to do if in doubt. I'm going to shift gears now and do what I think is the most boring part of the discussion, at least what I think is. This part does have black-white rules. This part is a bunch of musts, not shoulds. There are caveats to the musts. I'll talk about the caveats briefly, but these are, again, we're not going to spend a ton of time on this. These are, in my opinion, the most boring parts of the discussion about ethical considerations. but they are the legal requirements, okay? So anybody who thinks that I'm a member of a planning board or zoning board of appeals, and therefore I'm not a municipal officer, that's incorrect. These legal requirements come from provisions of law in New York that apply to municipal officers. And despite the handsome salaries you're paid to be planning board and zoning board of appeals members, which are of course not handsome at all, you actually are municipal officers. So municipal officers, members of town, village, or city councils, city boards, planning board, zoning board of appeals members are included. Okay, there are caveats to the rules. I'm going to tell you what they are because I think it's responsible to do so. But in the next breath, going to tell you that I try to suggest not focusing on the caveats, but focusing on the rules themselves. Build yourself a margin, strive high, shoot for over the margin, and therefore if you fall short a little bit, you'll still have cleared the minimum hurdle barrier. So the first rule is that municipal officers are prohibited from having an interest in a contract with the municipality. Municipal officers are prohibited from having an interest in a contract with the municipality. The caveat part of that rule is if the officer has some control over that contract for the municipality, but I say ignore the caveat. If possible, let's not have yourself in a situation where you have an interest in your private life in a contract with the municipality for which you serve as a planning board or zoning board of appeals member. The most well-known rule is the prohibited gift rule, a rule that comes up more frequently this time of year than any other time of year, but it's applicable across the board. This is also probably the only one you've heard of, and it's also the one that's always under pressure to change, but it hasn't changed now in many, many years. Municipal officers are prohibited from accepting gifts having a value of $75 or more, regardless of the form of the gift. I'm going to tell you the caveat in a minute because I think it's a particularly offensive to me caveat and a particularly stupid caveat, but it's in the law. But before I do that, let's understand we're talking about gifts in whatever form having a value of $75 or more. There's a lot of pressure to up that amount. When I started making this presentation more than a dozen, probably more than 20 now years ago, tickets to athletic events never cost $75 or more. Not necessarily right this minute during our COVID crisis, but in the modern era, if you go to a major league athletic event, probably in any of the 4 major league sports, an individual ticket is a triple figures expense. That happened to be one of the things that was given as gifts to municipal officials a lot. And if it's more than $75 or more, it's prohibited. The caveat, which I hate, is if attempted influence of the official could reasonably be inferred. Well, who's going to make that decision? And what does that mean, could reasonably be inferred? If I give you a $1,000 present, if I give a planning board member a $1,000 present the day of the meeting that night on my application, I think it's safe to assume that influence could reasonably be inferred. If it's somebody who's a friend of mine and I give them a gift a few months before an application is made and I really didn't know the application was going to be made, then I don't think anybody would reasonably infer that I did it trying to influence them, but it's a lousy caveat. If you're a municipal officer, try to refrain from accepting gifts having a value of $75 or more, essentially from people that would not otherwise ordinarily be giving you gifts. That's the best guidance we can give. And I do believe the rule will be changed. It just hasn't been changed yet. The last quote unquote rule is what we call the prohibited compensation rule. And the rule is a municipal officer may not receive or enter into any matter for compensation for services to be rendered in relation to any matter before any municipal agency of which he or she is an officer, member, or employee. What does that mean in non-legal mumbo jumbo? Well, it means 2 things. One, which is a must or must not. One, which is a should or should not. The requirement part is that as a board member, you cannot, meaning you are not allowed to, do work for pay before the board of which you are a member. You are not allowed to do work for pay before the board of which you are a member. Okay, that's the rule. That's not a hard rule to comply with, but the sort of the caveats and implications of what you might be allowed to do and still comply with the minimum legal requirement are not good. I think you should do way more than comply with the minimum legal requirement. So for example, in theory, that means you could work before the board of which you're a member, just not for pay. Don't do that. If you're don't be an agent before somebody for the board that you work for, if you can possibly avoid it. It also means you could work for pay before any of your sibling boards. So if you're a ZBA member, you could work for pay before the planning board and vice versa. Don't do that. I think it clearly creates an appearance of impropriety, and I urge you not to do that. Again, critical distinction. I am urging you not to do that, but it is not unlawful. Working for pay before your board is unlawful. It's a violation of a provision of New York General Municipal Law, which is where these legal requirements come from. Now, it's not unusual for a planning board or ZBA member to say, hey, no big deal. So I do break the law. What's going to happen to me? Well, any person who knowingly and intentionally violates state law is guilty of, including these laws, is guilty of a misdemeanor and can be fined, suspended, or removed from office. So bad things can happen. As I said a few minutes ago now, bad things can happen if you don't comply with these legal requirements. It's sort of an important aspect of this that is not as well known as I usually think as I used to think it was, is codes of ethics and boards of ethics. So the same statute in New York that sets up the legal requirements I just said also requires, as in must, not should, requires towns, villages, and cities to have and adopt a local code of ethics. It's required. By the way, the state statute sets out some guidelines for the local codes of ethics. Your local ethics code can be more restrictive. It can't be less restrictive. The misunderstanding, I think by now people know that our towns, villages, and cities have to, that's must, have local ethics codes. I think some people think they also must have ethics boards. That is not true. Many municipalities now have ethics boards or a board of ethics. That is not required. It's authorized, but not required. When we have an ethics board, it rules on specific situations arising in our municipality. The rulings are generally of an advisory nature. And then some people find this very frustrating, but under state law, the principal focus of the ethics board is financial conflicts of interest. We're going to talk about that in just a few minutes. But the principal focus is on financial conflicts of interest, not morals, not, was it ethical for the board member to say such and such at a board meeting? They said something that was discriminatory or what have you. That's not the typical focus of ethics legislation, ethics rules, and ethics boards. It's usually about whether local officials participated in something they should not have participated in, or somehow got involved in some financial impropriety. That's by far the most common, the most frequent topic that ethics boards and even ethics codes deal with, for better or for worse. Okay, so we're talking about, I just mentioned conflicts of interest. I think I mentioned in particular financial conflicts of interest. We're going to talk about conflicts of interest and appearances of impropriety. You're going to be struck, I think, by in many instances the lack of bright lines, but not none. Then we're going to talk about recusal, the mechanics of recusal, when it's supposed to happen, how it's supposed to play out. There we will also talk about some musts versus shoulds. Then we're going to talk about professional board members and appearances before boards. We just talked about that a little bit. We'll talk about it just a little bit more. And then we're going to talk about participation in planning and in the planning and zoning process by municipal officials as individual citizens, not in their official role, in other words. Then we'll sort of head toward the finish line, talking about some open meetings issues involving ethical issues, including site inspections and the like. And then we'll see where we're at time-wise, question-wise, and dialogue-wise in terms of planning the rest of our hour and a half together. So let's talk about conflicts of interest and bias and the appearances of impropriety. This is those are some of the words that you'll hear the most when we talk about ethical issues. And you're going to hear things like this. We must avoid conflicts of interest. We should also try to avoid appearances of impropriety. Yeah, That's true. What are we talking about? Let's add some flesh to that skeleton. There are certain situations that create what we call actual conflicts of interest. And actual conflicts of interest are prohibited, and you cannot continue to participate or cannot participate in a proceeding if you have an actual conflict of interest. Actual conflicts of interest typically involve some sort of financial incentive or financial involvement in whatever application is being heard by the Planning Board or Zoning Board of Appeals. So I'm going to give you, those of you who know me know that most of my hypothetical examples are kind of dumb. Like I still use Mother Teresa and Jack the Ripper, even though at least one of them has left us. But here's a real life situation. It was not a planning and zoning case, but it's so stark and so drastic that I use it as an example of a real conflict of interest. And this is a true situation that happened nowhere near the Capital District. This actually was an assessment matter, not a planning and zoning matter, but again, it's such a stark case. There was a member of a Board of Assessment Review someplace far, far to the south of the Capital District, but still in New York State, who said that he was going to, happened to be a gentleman, said he was going to submit a grievance petition for his own assessment to the Board of Assessment Review, of which he was a member. He said, however, and that you're allowed to do that, you don't lose your right to grieve your property. And that may not be bad for, it may be bad form, but it's not prohibited. But he said, I believe that I'm a very smart Board of Assessment Review member. I believe I'm a very independent, intellectual Board of Assessment Review member. And I believe that I can rule independently on my own grievance petition for my own property. So the analogy is I submit a planning board site plan review application for my own property, and I say I'm going to participate as a planning board member in review of my own application. Unbelievable, but the assessment story is a true story. Needless to say, there was a challenge. Needless to say, a court said in not as stark words as I'm about to use, but the court said that this was one of the dumbest cases. It didn't come far from saying this. One of the dumbest conflict of interest cases it had ever seen. And of course, the person could not lawfully participate. Okay, that's a no-brainer. When you have financial incentive because you have an interest in the application, you have a conflict of interest, you can't participate. The flip side may also be true, so that, for example, if you are the owner of the only hardware store in town and there's an application made to your board for a new hardware store, do you have a financial incentive to approval of that application? Maybe not. Do you have a financial interest in the approval or potential approval of that application? Presumably so. Your financial interest might be, unless you're an exceptionally welcoming hardware store owner, your financial incentive is to see the application not approved. That would still create an actual conflict of interest, and you should not participate in review of that application. The real, definite, crystal clear financial conflict of interest situations are usually reasonably clear. And in my experience, maybe I'm lucky, maybe it's because I don't practice in the portion of the state that gives rise to daily conflict of interest allegations. But in my experience, board members respect avoidance of real, actual prohibited conflicts of interest and don't engage in situations involving financial incentive or financial disincentive. And in my opinion, those are the easy cases. You also hear people like me and others say, we also want to avoid appearances of impropriety. What do we mean by appearances of impropriety? Well, we mean something that's less than an actual conflict, less than the prohibited financial incentive situation, but something that gives the wrong perception or impression. And the appearances of impropriety usually involve issues of bias, either real bias, meaning there really is bias, or a perception of bias, where whatever the surrounding facts and circumstances are, they give rise to an appearance of bias or appearance of impropriety. And we should certainly, I'm using the word should, not must, we should certainly strive as hard as we possibly can to avoid appearances of bias. Think of bias sometimes synonymous with predisposition. I either have a predisposition as a result of a bias, or it could be fairly argued that I could appear to have a predisposition as a result of a bias. And I want to strive to avoid those situations to the maximum extent possible. What are the facts and circumstances that give rise to appearances of impropriety involving bias and predisposition? I think these are largely obvious. I think that the facts and circumstances that could give rise to those issues are largely obvious. I think finding lines of demarcation about when they're crossed is far, far less obvious. But the predisposition / bias factors typically involve relatives. We already ruled out participating in anything that involves you yourself because that's just dumb. Relatives, okay? But everything has to be taken with a grain of salt or a rule of reasonableness. So a situation involving a relative, it's fair and reasonable to take into account the closeness of the relative familial relationship. If it's somebody who's part of your nuclear family, clearly there's an appearance of impropriety to you participating in a review of an application. Clearly. True story. Again, my hypothetical examples can be dumb. My true stories hopefully are not. True story. A planning board member in a relatively large community that I work for pulled me aside before a planning board meeting and said, Mark, I need to ask you if I need to recuse myself from this application. The applicant is my brother-in-law. I say, okay, it's your brother-in-law, not a member of your nuclear family, but let's talk about, brother-in-law can be a close familial relationship. It might not be. He says, I don't think I need to recuse myself because I can't stand my brother-in-law. And, I think I can be independent. I think I can review his application fairly and independently, but I can't stand him. But since I can be independent, I think I can participate. And I don't have the situation where it's like if it were my sister and she was the applicant, I would never participate because, of course, I couldn't separate out how much I love my sister. Okay? So therefore, the result is go ahead and participate? Of course not. The result is you clearly have a predisposition. You clearly have a bias. It's the exact opposite of the bias that the law presumes with a nuclear family member, but don't participate. It seems like a dumb example, but it's a true story. Martin, did you want to jump in?
Yes, I did want to jump in for two reasons. One, I wanted to remind people that if you do have a question, I love the material. It seems like people are enthralled, but if they do have questions or would like some more clarity on something, please use that chat function. I will unmute you to be able to ask your question. And now that I mentioned that, I'll ask my question. And you may get to this, so I apologize. Oftentimes in our proceedings, I sit on my municipality's Board of Zoning Appeals. One of the concerns that we have is our proximity to the property that is seeking a ruling on something. So we, for example, had a case a couple of years ago where it was a block away. I didn't think it had a financial impact whatsoever on my property, so I didn't believe it was necessary for me to recuse myself. But could you talk a little bit about, we're certainly cognizant of a particular project's impact on our own property or our property values. Could you speak to a moment about how planning boards and zoning board members may approach a situation where a particular development may impact their property or be perceived as impacting their property?
Absolutely. So let's do this because in my mind I have a certain order. I'm going to finish up. I'm going to talk about friends and acquaintances next, and then we're going to talk about neighbors. And in the context of neighbors, we're going to talk specifically about proximity.
Awesome.
So,
thank you.
Yeah, thank you.
Okay.
So I gave the pitch about the relatives. The same logic or lack of logic, however you want to label it, applies to friends and acquaintances. It is a more gray area, especially in a rural area like the real life situation I described earlier in the smallest municipality I work for. But friends and acquaintances, let's face it, there's quite the range. If the applicant was the best man at your wedding, then probably you should not only disclose, but not participate in the review of the application. If the applicant was the best man at your wedding 30 years ago and you haven't seen him since, maybe disclosure alone is enough and maybe participation is okay. But if the applicant is just somebody that you, and this happens all the time, even in not such small areas, if the applicant is somebody who you're acquainted with casually, your kids are on the same Little League team, you see them at the library once in a while, you drink beer at the same bar, whatever it is, it's a casual acquaintance. I don't think it's appropriate for somebody to say, if it's a casual acquaintance, you must recuse from participation in review of that application. But again, there's no bright line. You have to do what you think is most appropriate. We'll talk about who makes the recusal decision when we talk about what I consider to be a very important issue, which is the mechanics of recusal. We'll get to that in a couple of minutes. But now let's talk about Martin's question square on. Okay, mere proximity alone does not necessarily cause, mere proximity does not cause a prohibited financial conflict of interest. Okay, mere proximity would almost never constitute a purely a strong enough financial incentive to be an actual conflict of interest requiring recusal. However, proximity absolutely can, under the certain circumstances, can create a situation where one could presume a predisposition or a bias due to that proximity. So there might be an appearance of impropriety and it might be appropriate to recuse. But let's talk about what are the facts and circumstances. So mere proximity, absent any other relationship, wouldn't necessarily create a bias, and it would depend on the application and it might depend on the relationship. So in the example Martin gave, which is great because it's a real life example, I think he said, correct me if I'm wrong, Martin, it wasn't your next door neighbor, it wasn't the property right next to you. You said you were about a block away, roughly. A block in some places is super close, a block in other places is super far. But certainly you were right to conduct what I sent you conducted, which is an internal evaluation. And I think the result of your internal evaluation was, I clearly have no financial interest whatsoever. Presumably you had no other type of personal interest in the application, but you're only a block away. So
right, didn't know the applicant.
Okay, and you're acquainted with the applicant.
Away.
Right. So if it's a block away and it's somebody looking to add a second floor to their house and it requires a variance and I'm on the zoning board of appeals, what are the odds or what is the likelihood that somebody's going to think that I am so dramatically affected by adding a second floor on the house a block away that I have a predisposition or a bias? To me, that's a tiny, minuscule, infinitesimal, use whatever word you want to use. To me, I don't see how that creates even an appearance of impropriety because the house is a block away. How is it affecting my life if they put a second floor on it or not? Or they need a variance for a deck or whatever it might be. If what's proposed a block away is something that's going to change the level, the block happens to be a somewhat commercial block and there's a traffic signal at the corner of that block and the current level of service at that intersection is B as in boy. And I have reason to believe that the level of service at that intersection is about to drop to E as in Edward because of if this application is approved and this project is built and it's going to make my own ability to get into my house dramatically worse. Well, I might take the position as a board member, look, I'm only a block away from this mega giant project. I'm concerned that even if whether I even recognize it in myself or not, I'm concerned I might have some bias. And I'm also concerned that somebody might think that I'm going to view this project differently because I'm a neighbor than I would if I wasn't a neighbor. So I'm going to step out. I wouldn't fault somebody for doing that. I wouldn't necessarily say it's required, but I wouldn't fault them for doing that. Let's keep in mind, and as silly as this might sound, I want to say it anyway, by definition, you must legally, you're required to be a resident of the municipality on which you serve as a board member. So by definition, you know, if it's going to create a huge amount of traffic on a large road in your municipality, I don't think you have to say, look, I have to step aside because this is going to create a lot of traffic on this large road in my municipality, and I drive that road on my way to work. So does everybody else in the municipality. And you can't, that's why I always say when reasonably appropriate. That's why you take everything with a rule of reasonableness. By the way, a subject matter itself, a particular subject matter can create a bias or predisposition situation, arguably requiring recusal. So for example, and I'm dealing with this right this minute in 2 municipalities I work for, and I work for about 24 municipalities. A subject matter can create a predisposition or a bias situation so that, for example, if you're a member of a planning board or zoning board of appeals, you should not be signing the petition opposed to the blah, blah, blah project that's coming before your board or even your sibling board, because that creates at least an appearance of a predisposition and a bias. I would argue it creates more than an appearance, but it creates a clear indication of a predisposition and a bias. I have also dealt with a situation where somebody did appear as an advocate, both for and or against, not the same advocate, not the same project, a particular thing prior to being named to a particular board, then got named to that board, and then that applicant is before that board. If you've demonstrated that, predisposition, don't participate in your board's review of that application just because it doesn't look right. It doesn't look right. If we don't have any other questions about conflicts of interest and bias, I'm going to talk about recusal. I'm going to talk about recusal in some detail because it's actually one of the most common topics of questions that I get. So when I say I'm going to talk about recusal in some detail, I'm going to talk about two specific aspects of recusal. The first one I'm going to talk about is the recusal decision, what it means and who makes it. Surprisingly misunderstood. Recusal means you're not participating in your board's review of that application. It does not mean, I don't hear this as often as I used to, but I used to hear a board member from time to time say, I'm going to recuse from the vote on this application, but I'm going to keep my seat here and continue to participate as a board member until the vote, and then I'm just going to stay out of the vote. That's not lawful recusal. Recusal means I'm stepping out of this altogether. We'll talk in a few minutes, because our time is good. We'll talk in a few minutes about whether you can participate in some other fashion, not as a member of your board, not officially, but recusal as an official member of your board from participation in review of that application means you're not participating at all. We'll talk about the nitty-gritty details of that in a minute, but first we're going to talk about who makes that decision. Hugely misunderstood. Simple answer under law. The recusal decision is made by the individual, him or herself, by the individual. The recusal decision is not made by the board. It's not made by the chairperson of the board. It's certainly not made by the applicant or the public. It's made by the individual board member. Now, having said that, anybody who wants can weigh in on the decision, whether they're invited to or not. You can also, if you're a board member, seek advice or guidance from your town, village, or city legal counsel, from the Association of Towns, from the Conference of Mayors, from the New York Planning Federation, from the Department of State, from your ethics board. If you have an ethics board, you can seek advisory recommendation about your recusal decision from anybody you like, from your family members, from whomever, but none of those entities have the legal authority to say, here is the answer to whether you're recusing or not, and you must abide by it. And that's misunderstood. So I, for example, know of boards that the chairperson has said, Ms. Jones, I'm not allowing you to participate. You must recuse because blah, blah, blah. It's not up to the chairperson. It's also not up to the board itself. I've actually seen boards adopt resolutions by motion that say, we are barring Member Smith from participating because he clearly has a conflict of interest. You can do that if you want, but it's not binding on Member Smith. No opinion of anybody else is binding on Member Smith other than a judge. If there's a challenge, that would be binding on Member Smith. Otherwise, it's up to the individual member themselves. I certainly encourage them to seek advice or guidance from any of the entities I mentioned, but it's not required and it's not binding. Now, let's talk about the mechanics of recusal. And this is one of my pet peeves, and I admit it. My pet peeve is when somebody says, I recuse because the applicant's my brother, but they physically remain seated at the table, at the dais, at whatever you want to call it, with their fellow board members. And even though they've recused, they don't participate, but there's body language. There's an occasional laugh, or there's occasional groan, or there's an occasional whatever. I have seen recusal situations that, in my professional opinion, again, I don't like legalese, so this is not a legalistic term, that look ugly. They look horrible. And I'm thinking back to one in particular where the chairperson of a planning board I worked for said, I can't participate in this application because I stand to financially gain if it's approved. And the chairperson then actually did leave the table, but sat in the front row of the meeting room. And it was like the person was the Yankees third base coach signaling when to bunt or when to steal. They were giving, whether voluntary or involuntary, they were giving body language tips to their fellow board members about what they should or shouldn't do when reviewing the application. And it looked just awful. Important that I stress the musts and the shoulds. There is no legal requirement for the recused board member to physically go anywhere, okay? There's no legal requirement, but I was urged in the strongest terms possible. I said, this is one of my pet peeves. At the very least, physically step down from the board. Way better, leave the room. Get rid of any possible perception that you are having undue influence over your board. Just leave the room. Physical removal is not required, but it definitely adds to the integrity of the process. If you got to stay in the room and take a seat in the audience, I guess you got to. I don't know a reason why you'd have to. I would urge you to leave the room. Those are the mechanics of recusal. That's the musts, that's the shoulds. Some confusion about professional board members and appearances before the boards. We already told you what some of the limitations are. Some people take that too far and say, well, then let's not have members of certain professions be board members because of the ethical ramifications. In other words, some people say, don't let engineers, architects, surveyors, realtors, or God forbid, lawyers be members of planning boards and zoning boards of appeals. I myself don't hold that opinion. I think professionals, members of any of those and a bunch of other professions make excellent board members. We already talked about what they can't do in front of their own boards. And if it's too small a town, village, or city, you probably won't make sense because you'll be recusing so frequently that, you're not necessarily a very valuable board member. But I think professionals of those professions, members of those professions and lots of others make excellent board members as long as they abide by the rules and guidelines. So don't automatically rule out having quote unquote professional board members, meaning board members of certain professions that may be involved in planning and zoning issues. Okay, I said what I said about conflicts of interest and bias and recusals. I said you can't participate officially as a board member if there's a prohibited conflict of interest. I said you should not can't, but should not participate as a member of your board if there is an appearance of impropriety due to a bias or a predisposition, or at least the appearance of a bias or a predisposition. This situation that I'm about to describe comes up. Well, let me talk about the one that doesn't come up that often. Then I'm going to talk about the one that does. The one that doesn't come up that often is, can I make an application of my own? Applications by municipal officials. Here I'm going to lapse into legalese. I'm going to do it super fast, as fast as I possibly can. And after I lapse into legalese super fast, I'll tell you why I did it, because it's another one of my pet peeves. When you're appointed, excuse me, to the lofty position of member of a planning board or zoning board of appeals by your municipality, and again getting that handsome compensation I referred to earlier, you do not relinquish your rights as a citizen of the state of New York and county of whatever, and town, village, or city of whatever. You do not relinquish your rights as a citizen. A town that I worked for a while back, I ran into the town supervisor. This is, again, a true story. I ran into the town supervisor's wife at a social function, and she said, I can't wait till my husband's no longer the town supervisor. I assumed she meant because she was sick and tired of getting the 2 a.m. phone calls about barking dogs. But I happened to ask why, and she said, because we want to put a deck on our house, and we know that we need a variance from the zoning board of appeals to do that, and we can't do that while my husband's town supervisor. Nonsense. You don't relinquish your rights. Of course you can do that. He happened to be the town supervisor. If he was the chairperson of the zoning board of appeals, he's allowed to submit a deck variance application. And our New York State statute governs that very situation. And here is what our New York State statute says about that. I'm going to purposely read the provision as fast as I can. Don't be troubled by the speed at which I do so, because then I'll share my pet peeve. Here's what the statute says. It says, every application, petition, or request submitted for a variance, amendment, change of zoning, approval of a plat, exemption from a plat or official map license or permit pursuant to the provisions of any ordinance, local law, rule, or regulation constituting the zoning and planning regulations of a municipality shall state the name, residence, and the nature and extent of the interest of any state officer or any officer or employee of such municipality or of a municipality of which such municipality is a part in the person, partnership, or association making such application, petition, or request, hereinafter called the applicant, to the extent known to such applicant. Why on earth did Mark Schachter just waste your time doing that? To share one of his pet peeves. I just read you verbatim, word for word, one sentence of a state statute. What's my pet peeve? My pet peeve is, why do legislators adopt legislation that has, by the way, there are 107 words in that sentence. Can there be a comprehensible, understandable 107-word sentence? In my opinion, absolutely not. People gripe about the complexity and difficulty in understanding our New York State laws. That's my pet peeve. It's not a popular pet peeve for a lawyer to make, because I guess it's part of what keeps us going. Nonsense. There should never be a 107-word sentence. There should never be something that's so incomprehensible, especially because that 107-word sentence can be boiled down to 6 words. What did I just mumble and garble about? What did it mean? It meant disclose if applicant is municipal official. 6 words that take the place of that 107. Okay? So it's mandatory disclosure. A gentleman I worked for many, many years and still do, was a member of a town planning board, then became a member of a town board, had a pretty significant application in front of the planning board and I believe the zoning board of appeals as well. He wrote these words on an index card and he came up to me before a meeting and said, Mark, how would you feel about me reading these words in before my agent presents my application? He was wisely not presenting his own application. He had an agent doing so. He said, how would you feel if I say these words? And he wrote them on an index card. And I read the index card. Here's what the index card said. I'm a member of the town board and former member of the town planning board. I seek no different, special, or preferential treatment, and I should be treated just the same, neither any better nor any worse as any other applicant. What do you all think of what he wrote on the index card? I thought it was outstanding. I said to him, if you don't mind, I'm going to keep the index card when you're done. Please give it to me. He did, and that's why I use it. I think he did a fantastic job. He did tell me, by the way, it was a 5 or 6 month approval process. I can't remember which. I said to him, so how do you think it went? He said, I think it went horribly. Yes, I got approved eventually. I think they bent over backwards so far not to give me preferential treatment that it would have been a no-brainer 2-month deal if it weren't me. That was his opinion. That's fine. What do I think that's a good result? No, I think it's a great result. I think the municipality and the board member both did a fantastic job. The thornier issue, go ahead, Martin.
If it's okay, I'd like to allow one of our attendees to buzz you with a question here.
Please.
It's a good spot. All right, William, you are unmuted if you'd like to pass your question along to Mark.
Mark, you were talking about the recusal process and the individual who he's the only person who can recuse himself. What happens when you have a situation where you have a board member, a particular board member, who does not recuse himself on multiple occasions on multiple instances? What's, other than a challenge to the decision, how do you change that?
So inherent in your question is that the board member is not recusing themselves from matters that they really should be recusing themselves.
True.
And I do not, you're not going to like, neither you nor anyone else should like my answer. There's not an obvious avenue. I think the question, which was very insightful, was something like, how can you change that? Or how can you get, what can you do about it? There's not an obvious avenue to effectuate change in that pattern of behavior. Now, having said that, you said short of challenge. Yes, it can be a decision in which that individual participates can be subject to legal challenge, and they may learn the hard way. If they learn the hard way, it's played out the way I described earlier in the court challenge, I said. The other thing the other two things you could do, but one is likely not to work. One, I have no idea. The one that's likely not to work is in some non-open public meeting setting, approach your, and not a quorum of your board, but either you individually or less than a quorum of your board, approach your board member and say, hey, we'd like to talk to you about this. We think you're and put it on the board. We think you're jeopardizing our decision-making process by continuing to participate in decisions that we really don't think you should participate in. We're afraid that there's going to be challenge, that it will be successful, and that we'll have to redo some of our decision-making. May work, may not work. Seek voluntary recusal from that board member. You could also go to your legislative body, meaning your town board, village board, or city council, and tell them about your concerns, and they might rethink whether to reappoint this person when their term is up, or they may consider something more drastic if they feel it's warranted and necessary, and might consider trying to remove that person from your board. But those are the only avenues that exist. There is no appeal process when somebody says, oh, I'm not going to recuse. Those would really be your only opportunities.
Thank you.
Something else, or should I keep going?
No, we're all set. Thank you.
All right. So the next thing I want to talk about, and again, this comes up more frequently, not only than I anticipated it would, but more frequently than I should, because I think it's a lousy practice. Again, Mark Schachter's opinion, lousy practice. Prohibited not. What is the practice I'm talking about? Comments by municipal officials on the applications of others, but not as an official board member, okay? So again, you've heard me say now at least twice, you don't relinquish your rights to participate in an application, either as I said, as an applicant. You also don't relinquish your rights legally to participate as an individual member of the public, John Q or Jane Q public, not as a board member, sort of quote unquote from the audience, just as any other member of the public. This, of course, means if you are not participating in the board's review of the application. So in other words, I'm recused from participation because I do have either an interest or an appearance of impropriety, or at least a potential appearance of impropriety. So I'm recusing myself, but I have some strong opinions about this application. I want to go sit in the audience, and then I want to be called on during the public hearing to share my opinions. It's very important I make this critical distinction. That is not legally prohibited. You are allowed to do that. You must, of course, state on the record, I'm, Jane Smith, I'm a member of the Zoning Board of Appeals, but I've stepped down, I've recused from this application. I am not speaking on behalf of the Zoning Board of Appeals or on my official capacity. I'm speaking strictly in my individual capacity as a citizen of the town or village or city, and not in my official capacity. Two things are clear. One is you are legally allowed to do that. And I think just as clear is it's a lousy practice. I think it does create an appearance of impropriety. When I've seen it done, I've seen it unduly influence the board, no matter how many disclaimers you and the board give. I think it definitely creates an appearance of impropriety, and I would strongly urge that it not be done. But I also have to say it is not prohibited. If your view is important and it's got to be heard, get somebody else to say it, even if it's your own family member. But you are allowed to do that.
Mark, we had a question come across. I'm going to relay. It's a situational question. In this particular example or question, the attendee brings up, a planning board member had a past private conflict with the developer that was well known to, I'm assuming, to many members of the community. And the developer brought a project to the board that is separate from the past conflict. But given the dislike or public discourse between the developer and the planning board, would you recommend that planning board recuse themselves in that consideration because it may bring the appearance that they have a predisposition?
Right. So again, if we were not virtual, I would ask audience members to weigh in on that. Here's the best answer. It sounds like under that situation, you would all agree, we would all agree that there is not now in the present tense a prohibited or actual conflict of interest, meaning there's no financial incentive, disincentive, what have you. I'm going to say there's no longer. It sounds like there was a time when there would have been a prohibited conflict of interest, but that is no longer the case. And by the way, while that may or may not have been a hypothetical question coming from the attendee, we've dealt with that exact real life situation, actually at least twice that I can think of just in the last couple of years in two of the municipalities I work for. So let's think back about the way I've tried to provide guidance on issues like this and the rule of reasonableness and that sort of thing. If what was the relationship? They built something, they built a house for him, and they built something for him?
There was some situation of past conflict. I think I can kind of frame this in maybe a real world example. There's a particular development, a resident is not happy with it. That resident at the time or at some point forward becomes a member of the planning board, and the developer of that particular project comes back before the planning board or appears before the board. And that resident now has the opportunity to review that project. Should they recuse themselves, or what are the considerations if there had been some past public history between them and the developer? Right.
So rule of reason tells us this. If the application now back was for the same neighborhood in which I still reside, I'm not participating. If the application back, if it's well known that there was some friction, let's use that word, in the past, I'm the board member, I might be concerned myself about my ability to be unbiased, and I might be concerned about the perception that I might have a bias. I may lend toward recusal. An easier call, in my opinion, but a real life one of the two I've dealt with in the last couple of years, is the applicant is the contractor who built my house, and I'm a member of the planning board. When obviously, if the applicant was the contractor who was building my house and was still doing it while the application was before me on the planning board, I'm not going to participate because my appearance of impropriety is I don't want to annoy the applicant / contractor who's building my house lest he misplaced one of the reinforcement rods in the house that he's building for me. But in the real life situation that came up in front of one of the boards I work with about a year or maybe two ago, the real life situation was, yes, the applicant was the contractor that built my house. He built my house 15 years ago, and there's been no significant interaction between us during those 15 years. I think disclosing it is fine. I don't even know if disclosing it is required, but I said, my advice to the board member was, I don't see how anybody could tar you with a predisposition or a bias that would create an unlawful appearance of impropriety just because this person built your house 15 years ago. So those are both good examples of situations that have to be dealt with the rhyme of, or the rule of reason, because there's not right now, currently, clearly a prohibited conflict of interest. There's a potential appearance of impropriety, and that's where there's no bright line, and you make the most rational, appropriate decision that you can. Again, in my opinion, shooting for the highest standard, reasonably attainable.
Great. We had another question. We've got them coming in now. I think people are feeling more comfortable throwing these questions out there.
And more bored with me droning on, both of which are very appropriate.
That is a possibility. We can't rule that out.
That's right.
A question from Frank. Frank, I'm going to do you the honor of not butchering your last name and spare myself from embarrassment also. You are unmuted, so if you would like to pose your question, I can't unmute you. There we go. If you would like to pose your question to Mark, please do that. That way we can get some clarity on your question.
Mark, I understood your recommendation not to appear as a member of the public in your board, but how does that apply? I mean, does it apply equally to, say, your sibling board? As a planning board member, if you wanted to talk to the ZBA and their consideration of an item that may or may not, and I assume that makes a difference too, ultimately appear before the planning board.
Yes, I liked your last comment because you said it may or may not, and I assume that makes a difference. That was a very insightful add-on to your question/comment. So I think the answer is this. It's quite clear that you're allowed to appear before your sibling board and express your opinion. I think it's a bad practice, and I would recommend against doing so. Again, I have to be super careful of pointing out the distinction. Yes, it's allowed. I'm just saying I think it's a bad practice, and I would recommend not doing so. Why would I avoid not doing so? One, I think, somewhat obvious reason, maybe one less obvious reason. The somewhat obvious one is I think that human nature being what it is, if I'm a planning board member and I appear before the zoning board of appeals, or vice versa, there's just going to be a tendency to give me more, to take my comments more seriously, to give them more weight, if you will, because I'm a member of the sibling board, even though I'm not appearing as a member of the sibling board. But the other reason is why I thought your comment within your comment was insightful is you say, I assume it matters whether the application will be before my board. Yes, it absolutely matters, because if you've appeared before your sibling board and made a comment, and then the application appears before your board, you certainly would have what I would say would be an appearance of predisposition or bias slanted in whichever direction you made the comment before your sibling board. And let's remember something very important in that regard that people don't tend to remember. You might think today, okay, I'm safe, I can go appear and make my comment on this in front of my sibling board, despite the fact that it may be, deemed inappropriate because I'm using my position, to try to add weight to my comment. But remember that we don't always know for sure that the thing won't end up before your board, even though we think today it won't. The obvious example being a project that is not initially identified as needing a variance from the zoning board of appeals. So a ZBA member goes in front of the planning board and makes some comment as a member of as an individual member of the public. Oh, and then guess what happened? Either somebody looked at the plan more carefully and realized it does need a variance from the ZBA, or the planning board process resulted in tweaking of the application. So it's now going before the zoning board of appeals. Well, guess what? If you made the appearance we talked about, you've now knocked yourself out of the box from doing that. Meaning participating with your board in reviewing that application. So the answer in less mumbo jumbo, shorter words is it allowed? Yes. Is it a good practice? I would suggest for both reasons, it's not a good practice.
Mark, we had a question. If you could take a moment and discuss professional planners' conflicts or ethical issues. Perhaps if somebody is a planner and they themselves, their firm works for a municipality, or they frequently represent applicants appearing before these boards, what sort of ethical issues might come for them to represent themselves in front of the boards or participate in work with those municipalities?
So I'm going to say this. I presume there are people, there are attendees who are AICP, members of various planning organizations. I know, all I know, and you could even correct me if I say I know this, I'm pretty sure I'm right about this. I believe the AICP planners, there's a planner's code of ethics. There's a formal code of ethics, just like we as attorneys have a formal code of ethics, just like some municipalities have a code of ethics, but way more broad than the municipality's code of ethics. I do not know what is in the planning code of ethics in terms of that sort of issue. So the advice I give is quote unquote generic. And I would give the same advice to professional planners that I would give to members of the other professions. So that if you're a board member, you can't appear as in your role as a professional planner before one of the boards on a private matter. Of course, if you're employed by the board as a planner, you're not a member of that board, you're employed as a planner. I would give the same advice. The things that, at least under New York general municipal law, you can't do are appearing before your own board. You can appear before sibling boards. I don't know if the AICP or related planning ethics rules are more stringent or not. If they are, then you have to abide by them. If they're not, then I would urge you and your firm not to appear before the sibling board also. But you're certainly allowed to do so under the general municipal law provisions applying to planning boards and zoning boards of appeals. But there may be more stringent requirements under the planning rules and of ethics, and I don't know.
This is one that, another one I'm going to throw at you. This is one that comes from a person who is a staff at their county planning board or their county planning office. They have been advised, I'm assuming by their county leadership, not to sit on planning boards or run for municipal office in the towns in that county because of what they call conflict of interest. Do you think that's a fair assessment or a policy that is fairly applied?
I think there's some, I don't think that this person is not a member of the county planning board, is a staff of the county planning board?
Staff of the county planning office.
Right. So of the county planning office, sorry. So I'm pretty certain that there's not a prohibition under state law. There would not be a prohibited conflict of interest. We call this area of law compatibility of positions. And there are sort of two rules about compatibility of positions, painting with something of a broad brush. And the two rules are one obvious, one a little less obvious. The obvious one is that you can't hold more than one position where one could be deemed to be your own boss. So one could be deemed to be subordinate to the other. That wouldn't be the case in that situation, I don't think, if they're a member of if their job is they're on the staff of the county planning office. I don't think there's a situation where that position could be deemed to be subordinate to whatever the other office would be that they're elected or appointed to. The other one is that there's inherent inconsistency in the position, so that what's good for one is not necessarily or is necessarily not good for the other. I don't see, excuse me, I don't see how either of those would likely be true if I'm a staff person of a county planning agency and I want to consider being a member of one of these other boards. By the way, I can tell you that I know for a fact that such dual role, two hat wearing does exist, because I know somebody who's a member of a staff of a county planning agency and sits on a planning board. They sit on a city zoning board of appeals. So I'm confident it's not prohibited. I would not criticize a county that said to its employees, we would strongly prefer you not do that so we can avoid any claims of bias or appearance of impropriety. I think you could do that, but I don't see a prohibited conflict of interest.
Okay. Do you want me to keep throwing some to you, or would you prefer I space them out or save them to the end? We've got three more that.
Well,
I don't want to take you out of your vibe here.
Do we need to start it? Do we need to end at 12:30, or since we started 5 minutes late, do we go 5 minutes late? It's up to you.
We can go 5 minutes late, and I think this is great stuff, and I think these sessions always get folks engaged. For folks that are looking for their credits, they'll get an email when they log out for their time, and so that's something to be cognizant of. But if you're generous enough with your time to continue along late, I have no issue with allowing that to be the case.
All right, so totally fine with me, and we obviously won't criticize anybody who checks out. Here's what I'm going to suggest. The two other things I was going to talk about briefly were site inspections and what we call ex parte communications, meaning talking among planning board and ZBA members out of the open public meetings. My suggestion is, I don't care, Martin, you're the boss. But my suggestion would be we field a couple more questions, and then I'll spend 5 minutes talking about those things.
Yeah, I want to keep you happy as well. You volunteered your time. I'm really appreciative of that. You know, we wouldn't be able to do this without our speakers, so I want to communicate that I'm appreciative. The first question we had was, what if the board member is an attorney and had a past case where an applicant to the board was an adverse party?
What if the board member is an attorney?
Yep.
Excuse me, and had a past case in which, as an attorney, the applicant was on the other side of the past case. Am I right?
It looks like that's the case, where an applicant to the board was an adverse party.
So I would strongly suggest that my colleague attorney, my fellow attorney colleague, not participate in that case. I think they have to disclose for sure.
Mhm.
You know, this applicant was the adverse party in a case I was involved in. If the case was, 20 years ago and the subject matter was so far removed from what's in front of us, maybe I could live with disclosure alone. If the case was more recent and bore any relationship whatsoever of the subject matter, I would urge recusal. But if it were me, I'd recuse, because I would be failing the test that I described now almost 90 minutes ago, which would be the sleep anxiety test. I'd be worried that somebody would come rushing in and question my independent judgment because the person was an adverse party some years, even if it was years ago.
Okay. Let's see if I can allow, I'm going to allow some folks to ask their questions. That way we get some good kind of feedback here, if we could. I had a question from Michael Barden. And so Michael, I'm going to unmute your microphone here. And if I can, let me just see. Are you still on? Oh, Baden, I'm sorry. I have to spell your name right and I have to say it right. But it looks like, there we go. I'm going to unmute you. So Michael, if you'd like to pass your question along to Mark, please do.
Yeah, and are you hearing me okay?
We are,
You're
yes.
Great. First, hi, Mark. We've dealt with each other many times through the Planning Federation. I'm now the town supervisor, but I was the planning board chair, and I also was the chair on the county planning board. And here in Ulster County, we follow a very strict policy of that if you're voting on your an application that's before your own board, that not only do you not vote, you're not even allowed to speak. It becomes comical in that we have one member who brings very chewy candy bars, and we put them in front of the member to make sure that people don't resist the temptation to speak. Is there any situation that you can think of where somebody could offer information? As many times we have the members say, the referral to the county happened a month ago. Since that time, the local planning board talked about this, this, and this, and it gets very frustrating. Sometimes more information would be helpful to the county, but we don't allow it. And I'm just wondering if you can comment on that.
First, I have to ask the question, which is, I think I missed an important part of the factual setting. Is it a board member's own property as the application? Or
No. We have a rule, and I don't know if it's a state rule or just a local rule, that you cannot speak or vote on the county level if it's an application that's before your town board. So if you were a town planning board member and a county planning board member, when it gets referred to the county, you don't take part in it.
Right. So, okay. So no, it's not a state law. I personally think it's a healthy practice to a degree, but now I think I'm understanding your question better. Because you're the person from that municipality, you might have factual information that would be helpful. And because you're chewing on this caramel-laden candy bar to prevent yourself from speaking, you're not allowed to offer the factual information. Is that the context?
Oh, is that
muted?
Sorry about that. I'm too quick to hit the mute button here.
Yes, absolutely. That's the context. If you feel like you can bring anything to the table, should you be allowed to? No.
Right.
Yeah.
Got it. So here's my answer. In a perfect world, I like the rule, and I hope you heard me say it's not required by state law. I like the rule because it is a striving high type rule. In other words, it's going way above and beyond what's legally required, and it obviously prevents anybody from successfully asserting, excuse me, that there's a presumption of bias that's guiding the county planning board, because the person from that town hasn't said a word. However, your point's well taken, and it's in real life, it's absolutely 100% true that often that person from that local municipality would have information that could help the county planning board make its decision. In a perfect world, the county planning board has staff that's capable of asking the factual questions of their counterpart at the local municipality. So in other words, in a perfect world, the county planning staff would say to the town, village, or city planning staff, hey, we have factual information questions about blah, blah, blah. Can you fill that in? In the real world, in real life, and this is why my colleagues and I try to always give advice that not only technically, legally correct, but we have at least one foot on the ground, practical reality. In real life, the question doesn't come up till the day or night of the meeting. The county planning board is sitting there struggling, not knowing some factual information. The local person knows that factual information, but they can't say it because they're prohibited from saying literally a word. I would suggest that it would be appropriate to have the rule be not so inflexible and allow the local person to provide purely factual information if requested by the county agency, but not express any opinions about anything. I hope that answer makes sense.
No, that actually is very helpful. That maybe that if it was initiated by the county planning staff in the meeting, that might be helpful.
Yes, I agree.
Okay, thank you very much.
Thanks. We got two. I'm going to do two more, but then let's hold off for a little while. Folks are peppering me with great questions, and I love referring them along. I'm going to refer this one because I think I can understand it pretty well. If a planning board member signs a broad petition opposing a new residential development, or is a member of a group sponsoring it, is it a bias or predisposed opinion regarding any residential development that comes before the planning board? So it looks like they signed a petition against a particular development. Does that represent a bias across the board for any residential development?
Yeah, or in support, same, either way.
Correct.
So I'm gonna do one of the many things that lawyers are terrible at and that we're trained to avoid is one-word answer. My one-word answer is yes. I think it does create that appearance. Now, if it were far enough in the past, I might feel otherwise. If the petition was so broad that now what's being proposed really doesn't even relate to the creation of the entire neighborhood. What's being proposed is some narrow specific thing. So let's make it a ZBA member instead of a planning board, and the ZBA member signed a petition opposed to the development of this 1,000 unit single family residential subdivision. Now, and this was 10 years ago, now it's 10 years later, and one hapless homeowner in that 1,000 unit residential subdivision comes before the zoning board of appeals seeking an area variance to put a 6-foot area variance to put a deck on the side of their house. In that situation, do I think the zoning board of appeals member must recuse themselves because 10 years before they signed a petition opposed to the blah, blah, blah residential 1,000 unit subdivision? That's such a far-fetched nexus that I would say they probably don't have to recuse themselves, and I'm not even sure they have to disclose if it's 10 years later. But on the flip side, real life happened. Somebody signed such a petition and appeared at a town board meeting opposed to a proposed rezoning to facilitate development of a large-scale residential subdivision. And then just a few months later was named to the planning board, and then that subdivision, the zone change was adopted. Now that subdivision is in front of the planning board. I think that planning board person has clearly expressed at least the appearance of a bias or predisposition by having signed the petition opposed to that subdivision and should not even consider participating. Okay.
Thank you very much. And our final one, and then we'll pause for a little while, let you get back on your track here. If you have this may apply to the City of Albany moving forward. If you have a 5-member board and no alternatives, a recusal is effectively a no. Should that be a factor in considering whether to recuse the case?
Yeah, so that's a very insightful question. I hope inherent in that question, Martin, is not that I'm hearing that one of the land use boards from the City of Albany still does not have alternate members, but if it doesn't, I wrote an article about misuse of alternate members in a statewide publication that was met with, not for me, an unusual amount of pushback, but I always used to take the survey at almost every conference. How many municipalities, raise your hand if your municipality has alternate members or doesn't, whichever side I would ask about. And I was very pleased, because I'm a big fan of alternate members. I was very pleased to see that the number really shifted over the 20 years to way, way, way more having alternate members. But the answer to the question is, can it create a problem? Yes, it can, especially if somebody's absent. Then we're knocked down to bare majority. So yes, it can create a problem. You don't want to, excuse me, you don't want to paralyze your board. Paralysis can reasonably be avoided. So that's an example, or an example of a situation where if it's a close call, maybe if you were a 7-member board, you would recuse yourself. But because you're a 5-member board, maybe you disclose but don't recuse and roll the dice and take your shot, because you don't want to paralyze your board. That's, in my opinion, that's a pitch. That's another pitch for alternate members. But you don't want to paralyze your board.
Great. Thank you very much for that. And we'll let you get back on track. And I do appreciate the feedback. Typically what we've done is have people type in questions, and I don't do the unmuting and letting them ask. And it's been fun. So I appreciate this opportunity. I'm kind of feel like a radio DJ here. We'll be
good.
After the commercial break.
Exactly. And for what it's worth, for what it's worth, this is by far my preference for how to go about it also. So I'm sure people will start dropping off like flies momentarily. So I'm just going to wrap up for 5 minutes or so. I think that'll be putting us in about an hour and a half, which is what we were talked about. Mm-hmm. So I'm going to talk about 2 things left. One is site inspections, because there's, again, in my world, a surprising level of misunderstanding about site inspections. And why is this an ethical consideration? Because sometimes people raise their hands and say, wait a minute, it's an ethical breach for the following to happen in respect to site inspections. And then I'm going to talk about, but actually I'm going to do it in opposite order. I'll save site inspections for last. First, I'm going to mention one of my remaining pet peeves on an ethical issue. And that is what I guess I'll call abuse of the open meetings law. And it's not really, that's a misnomer or a mislabel that I've just given my own pet peeve. People don't break the open meetings law that frequently by physically gathering a quorum outside of the open public meeting. But what people do all the time is have what we call ex parte communications. And by ex parte, we mean out of school or outside of the open public meeting. In a perfect world, and I know it's not a perfect world, but I think there is an ethical problem when boards start communicating among themselves or with applicants or their representatives to a great deal outside of the open public meetings. And this is something that was less of a problem in the days of old and is more of a problem now with email and social media and other means of communicating. So when the planning board or zoning board of appeals members en masse engage in email communications back and forth about pending applications, and especially when they're doing it, like within the same hour, all of the members of the planning board and zoning board of appeals are sending emails back and forth to each other about the merits of a particular application. There's not yet a court case deeming that to be a violation of the open meetings law, but there are Committee on Open Government opinions that call that a virtual meeting, and that say that the Committee on Open Government believes that such a virtual meeting that does not comply with the provisions of the open meetings law should be deemed illegal. I feel that's very strongly, it should be deemed illegal for that to happen, because I think it takes an integral portion of the decision-making process out of public realm and out of public view and out of public scrutiny. And if you remember now, 90 minutes ago or 88 minutes ago, one of the basic fundamental overriding premises I mentioned was that applications should be decided based on information presented, reviewed, discussed, and decided at an open public meeting. So when there are ex parte communications between and among planning board members, even if it's not a quorum, but a number of them, with each other, with the applicants' representatives, with neighboring groups, with whomever outside of school, I think it flaws the planning and zoning decision-making process. And because those things happen all the time, that's one of my pet peeves. This, by the way, is one of those things easier to say than do. You run into people in the grocery store who say, I want to talk about the blah, blah, blah application. You tell them as politely as possible, I'm not supposed to talk about it in the grocery store. Please come to our next meeting. It's on Tuesday night at 7 o'clock. you can't come to the meeting, please submit a written comment. And then lastly, I'll wrap up, although I'll be happy to take a couple of additional questions if people want, but I'll wrap up by talking about site inspections, because it's a frequently misunderstood topic that does give rise to ethical questions / concerns. The range here is larger than I ever would have imagined. One end of the range is people who say it's an ethical violation for a board member to go visit a site, so site inspections are either illegal or inappropriate. The other range of the spectrum is site inspections are required by law. The entire board must go to the site. They must do so together, and it's an open public meeting that anybody who wishes can attend. Both of those statements at the outer edges of the spectrum share only one thing in common, and that is they are both 100% incorrect, 100% false. In between the outer extremes are a number of things that are perfectly appropriate or perfectly correct. Site inspections are neither required nor prohibited. Board members can go individually, but contrary to some misconceptions, board members can also go en masse. Some municipalities schedule it like a caravan, and there's an actual van that picks up with the whole board and drives from site to site. People say, well, then it's got to be it's got to be a violation of the open meetings law. It's a quorum. They're conducting business. Yes, it's a quorum. No, they're not conducting business. How is it that they're not conducting business? Because they are ascribing to this, they are religiously ascribing to this rule. It's the rule that I call the rule of the sponge in site inspections. They are taking in information, but they are not discussing the application. Now, hyperliterally, that means they're not saying a word, like the poor gentleman from Ulster County who has to chew on that caramel peanut butter laden candy bar. In real life, are you not saying a word? No, because none of us are hopefully that rude. Remember that when you do a site inspection, whether it's by yourself, with a fellow board member, or with all of your fellow board members, one miracle happens at every site inspection, regardless of how announced in advance it is or not. What is that miracle? The applicant happens to be there. If it's not the applicant, it's the applicant's agent. But somebody's there, even if you traveled under the cloak of darkness at night. When you do a site inspection, somebody's there from the applicant side. And despite me and others saying, don't discuss and deliberate the application, it's human nature to do so. And it's also human nature for the applicant to try to tell you why this is the best application that's ever been before your board. You have to fiercely resist that dialogue. You have to tell your fellow board members, we're not here to discuss and debate the merits of the application. However, as a sponge taking in information, if you have a pressing factual question, kind of like the situation that the gentleman asked about in Ulster County, if you have a pressing factual question, it's okay to ask the applicant or applicant's representative or your fellow board member, because don't waste your site inspection. If you're like me, the site inspection is worth 1,000,000 words, not 1,000 words, not 100 words. And I want to know where that berm is going to be built. But remember, when you ask the applicant to show you where that berm is going to be built, 0% of the time will the answer be right here. Why will the answer not be right here? Because the answer will be right here. And this will be the finest, best constructed, most beautiful berm that has ever been built in the continental United States. When that's the answer, you have to try your best to ignore that part of the answer and just say, okay, I see now the berm's going to be built right there. Or the line of sight is right down the road is over here, or whatever it is. You're taking in information, you're not discussing or deliberating, and that's how you're not violating the open meetings law. So I'm going to wrap up. If anybody wants to ask a question or two, I don't mind sticking for another couple of minutes, but I'm going to wrap up by saying, I hope I didn't woefully disappoint you, because there are not so many bright line, black, white rules about ethical behavior in planning and zoning decision-making. If nothing else, I hope I've given you food for thought about how to behave as ethically as possible, and hopefully giving you some guidance as well about what the rules are and what the goals might be.
Absolutely. Ethics is a fascinating topic. I think we can all dive in deeply. One of my favorite television shows as of late, The Good Place, dove into ethics with quite a lot of comedic substance. So always appreciate these discussions. What I'll do is I'm going to share my screen here, and I'm going to share your contact information, not my Gmail. So there is your contact information, Mark. I really want to thank you for being generous with your time today and taking questions from our audience members. Folks, we do archive these. We will be posting this to YouTube. and that link can be found on the Eventbrite page. It takes a little while for that to download and process, so be patient with us. But again, Mark, thank you so much for sharing your time with us and your expertise. Really appreciate that. Folks, we'll be back next Wednesday with another webinar. We'll be doing them through the end of the year. 2020 is almost done and our series is winding down also. So please check out that Eventbrite page. We're constantly adding webinars. Thank you very much for allowing me the opportunity to be a radio host. It is my freshman college dream come true. And hopefully we'll see a lot of you next week. Thank you. Take care. Bye-bye.
Thanks a lot, Martin. Thanks a lot, everybody. Have a great day.